It's loading right now. You'll get a message that it's being streamed in a moment. That's good. Okay. Okay. I apologize. We are now, the door to the courtroom's unlocked for the public. If they want to watch on YouTube, they can. Was it the court's intention to hear matters without it being open? But it is open now. And if any of you want to go back and restate your arguments, I'll let you, but I don't need you to for me. I appreciate, Ms. Wood, your pointing out that your exhibit, for the purposes of this hearing, your proposed exhibit 2 and proposed exhibit 5 are not being offered as evidence in the case.
No.
And that the other 3 exhibits are actually already in evidence. But you also pointed out that for convenience and to make proposed exhibit 2 that is not being offered for evidence, and proposed exhibit 5, which is also not being offered for evidence, in order to make those more usable, you went through the other exhibits and gave them page numbers at the bottom that you could refer to.
And only respond. I don't think there was a summary on respondents exhibit 5.
That's fine.
But it's, again, it's just so that we don't sit here for 4 hours, because obviously with my summary, I can walk us all through it, but it's just so that if you.
Well, and that's not necessary. And I understand. So I'm not admitting any of the exhibits that you've offered for this hearing as evidence today. The other 3 are previously in evidence already. The 2 new ones, which you're offering only as demonstrative aids or essentially argument to the court will accept as tools that you're offering to make it easier for me to find the references. I don't have a problem with that. They're not evidence in the case and are essentially a part of your argument. I've looked through the material that has been submitted and will consider the evidence as only those matters of evidence that were previously introduced. And I'll consider the arguments you've offered today as argument and the written documents you've submitted as argument. And I will take those into consideration when I order a distribution of the proceeds that are, when I sign a final decree in this case and order a distribution of the proceeds that are in the registry of the court. That's essentially what everybody wants done, isn't it? For me to get that done. Now, Ms. Lamas, your client needs those proceeds immediately so that she can comply with the court's order to pay the $60,000, the balance of the $60,000 note. You've pointed that out. And Ms. Wood, you've pointed out in your argument that you would like to have time for that to go through the possible appeal process if there is one and that sort of thing. And I understand both arguments.
And we have reached an agreement, Your Honor, as far as, as far as not all the distribution, but we have agreed that you suggested last hearing that the amount needed to pay off that note that was awarded to the obligation of Ms. Cummings would be just a check would be sent to First National Bank of Evant, and whatever that amount was, 60,000 plus what I guess she may have a little more interest, then that would be counted towards her share of the distributions. And I let Ms. Lamas know that I either needed the number or the order, but that we were in agreement. I'm sure she's busy too. I'm happy to draft that order, but I need to fill in that number for you, whatever it's going to be, 60,100 or whatever it's going to be, so that that particular amount could be released immediately so that she's not incurring more interest. Nobody goes into default. The bank gets their money. That, I mean, to me, that just seems fair.
Ms. Lamas, response to that?
I'm sorry, and I told Ms. Wood I would draft that order, and I have literally been in court nearly all week. I left the courthouse Wednesday afternoon at 5:45. And Tracy's been out, and it's just been, this has just not been a good week. I'm hoping I can work on the order today. I don't have a final number. My client's been out of town working, and I don't.
That's fine. Y'all get the number from the bank, but in principle, you've worked out an agreement to have those funds released from the registry of the court and paid directly to the bank.
That's correct.
Yeah.
Yes.
Send me an agreed order to that effect. And then when the court orders a distribution of the funds, that amount will be, we'll have to work it out, but that amount essentially will be taxed against Ms. Lamas's share of those funds. And not Ms. Lamas's,
Ms. Cummings'
Cummings' share. My apology. Anyway, Ms. Cummings' share of the funds. And so that, anyway, that, get me a agreed order, send it over. I'm going to be out of town this afternoon and won't be back until late, but you know, anytime you get me that order, I'll get it together. I'm going to take all of the information you've sent. I am going to ask y'all to do two additional things. Get your secretaries or yourselves to send me a copy of each of the proposed decrees and to send it in a Word format. Okay. I anticipate that the court will enter a ruling that is close to something. That's a terrible way to put it. I anticipate I'm going to be making changes to either or both orders if I do something, and coming up with a ruling that I believe reflects my letter ruling and my reconsideration to whatever extent that's I consider appropriate. But I will look and consider the argument on reimbursement in connection with the distribution, and I'll try and make more clear my rationales in regard to that. But that's not important. You know, in fact, I can just rule, as y'all both know, and then you can ask if you want to for you know, conclusions and that sort of thing, and the process that's involved there, and this can continue on for years. I sincerely hope it doesn't, for both your clients' sakes and y'all's sakes. This matter needs to be wrapped up, and people need to be able to get on with their lives. Could
I ask for a couple of points of clarification just while we're all here?
Sure.
And this came up originally when we were talking about getting the house sold, and you know, we said we'd put it off. So there are two Jeep vehicles involved in this lawsuit. Yes. And so it was really unclear because I understand Ms. Lamas's interpretation, but also you know, when I read it, I see my interpretation as well. So my thought was that you wanted Miss Knott to have the vehicle she's had all along, the Jeep Wrangler, and that was going to be her, even though it's collateral, part of the collateral for that $60,000 note. She was going to get her Jeep, and then Miss Cummings was going to get the Jeep Patriot, which is in her possession, and which may be collateral for something else, but it's not collateral for the $60,000 note, and the Airstream. And so I just wanted to clarify one way. I mean, am I correct? Is that what you intended to do with your letter ruling, or no? Is
there confusion on your part, Ms. Lamas?
No, sir.
Okay. So yours is that Ms. Knott gets the Wrangler. Your interpretation of what I wrote is that, and that the Patriot stays with Ms. Cummings.
correct? And that Ms. Cummings gets the $60,000 note.
Yeah.
That's the way I read your ruling.
That's what I intended in the ruling. And I was concerned, of course, that there was a burden of that particular wrangler being on the collateral. But I believe if you send that agreed order over and we get that paid, that'll resolve that issue.
Correct.
And
We just need to get the title to the Airstream from Ms. Knott.
Yeah.
and as soon as that's paid, we'll get that.
Yeah. Send it.
Yeah.
If we have trouble getting titles and stuff like that, we'll do. We'll spend more of the party's monies holding hearings for clarifications on that. And I don't think anybody wants that. I think that'll all get taken care of. And if the titles are lost, then we just need affidavits so that they can be reissued.
I don't think
and all of that stuff. You guys have done enough divorces to be able to figure out how we get that done, and we can clean that up. All right, I'll let both of you.
One more issue. There was one issue, and I know it's in my document, but it's like at the end after all the law, and that is that we never got a ruling as to whether Ms. Cummings needed to return the military ID to Ms. Knott, which she had requested that, once the divorce.
If Ms. Cummings has the military ID, it needs to be returned. If she can't find it, doesn't have it, I need a statement or an affidavit from her to that effect. Okay.
I can get it from her. I need to get I'll return it as soon as
you need an order. Yeah, you need an order.
That's
and
fine.
That's fine. Okay, I understand all of those things.
Okay.
Yeah, we can put it in the order. That's and send me a copy of both y'all's orders in Word so that I can do cutting and pasting if I need to. That's essentially why I'm asking for them in Word.
Sure.
And
do you want me to take out the red line? Because I'd put that in there so you could.
I can take it out.
Okay.
Send it to me in Word. My Word program will. If I have a problem with that, I'll send you an email back saying, please take out the red line. But I think I can mess with it on my computer and get that taken care of. And frankly, the red line's helpful.
Okay.
And there's a couple of places where it should have been redlined and it wasn't, but that's fine too. Well, it would be the same way if I had done a red line for y'all. So anyway, that's just the way that works when you do red lines, but I appreciate the work that was done with that. It makes it easier for me to integrate a ruling that I think incorporates all of my intentions in the matter. Whether the parties or y'all agree with them is another matter, but it does make it helpful for me to make the ruling. I will try and get the ruling back to you before Friday of next week. Okay. So I'll move as fast as I can. Y'all give me that agreed order in regard to the payment on the note. I'll get that signed and sent back to the clerk. And whoever drafts that order might run a copy of it by the clerk and say, if I send this to you, will you be able to do it? Do you understand it? Is it clear enough that you can actually cut a check and get it done and run it by them? I think they'll probably say it is, but if it isn't, it'll be helpful if you get their clarification of the language they need. Okay. I do not know how many accounts the money has been placed in. And I didn't ask. I did tell them that I wanted them placed in an interest-bearing account. We had some choices. Right now, it's in a savings account. It's not a lot of interest, but it's interest. And that's because that way we don't face a potential penalty if I order a distribution out of it like we're talking about doing right now. So it'll just be a simple matter. I also asked the clerk to check in and make sure, because of the amount of the proceeds, how many counts she would need to deposit it into. And the only reason for that was FDIC insurance. I didn't want them sitting in an account that if this particular bank folded, which I have no suspicion that it will, I hope it doesn't. My money's in that particular bank in another town. At least some of my money is, not nearly enough. I wish I had more. But anyway, and that's not a request for anything, guys. That's just piffle. But anyway, Bancorp South bought out my old bank, and I don't know. I don't like big corporations. But anyway, my money's sitting there, and if that bank were to fold, I'm more than covered with FDIC insurance. But those accounts exceed 100 to 200,000 in each account. I mean, we're looking at over $400,000 there, and I wanted to make sure it was in an insured account and wasn't in excess of what the required insurance levels were that the bank carry on the accounts. So I asked the clerk to check into that and make sure it was in an insured account and split it up into however many it needed to be insured. So that's just an FYI. And probably something you didn't need to know or want to know. Okay, we're done. This hearing is concluded. Appreciate all you've done. You follow up on the other stuff, and I'll follow up on my end. And I will do my darndest to get you all a written decree and all of that by Friday of next week.
Thank you.
Okay.
Excellent.
Maybe
God
we-
bless you all.
Thank you.
See you later.